Good morning. A case of 397 and 394 convicted in the year 1994, and subsequently Supreme Court seems to have acquitted in the month of March 2023. The reasons behind the acquittal may help you. The reasons given by the lower court was, Supreme Court was, it's a case that the accused armed with drawn knife, pistol, and they were apprehended and they have handed over. Subsequently, what happened? Even though there are other important witnesses reached, and the witnesses stated that they have apprehended some of the accused and subsequently they failed. The FIR was lodged and the accused names were mentioned in the FIR. They were arrested and some of the amount pistol were recovered and weapons were recovered. But the Supreme Court, what Supreme Court says, this is what very interesting. It may useful for you. Supreme Court says the pistol was subsequently after 3 days recovered from his packet, pajama, country-made pistol. Supreme Court says it is not believable how a man can keep always a pistol in his packet. This is what the Supreme Court says. Then the names stated in the FIR is somewhat confusing, interchanged. Therefore, they disbelieved FIR and important witnesses not examined. They say the Mahinder Singh, whose name is available in FIR and whose arrival scene of crime the accused ran away, has not been produced by the prosecution. He is a material evidence. So on this score, the Supreme Court acquitted 397 and facts is absolutely within the ambit and ingredients of 394, 397. This is AR 2023 Supreme Court 1677. AR 2023 Supreme Court 1677. Anwar alias Bugru versus State of Haryana. Anwar alias Bugru versus State of Haryana. This is most important. Kindly go through the judgment, which may help you in defending 394 and 397. And so far, the topic or concern. The other day, when Sendil Balaji arrest was discussed in media, somebody says Indian Evidence Act speaks about the it is duty of the prosecution to the prove case. So that is why I say that unless and until you understand the historical background of jurisprudence means the subject of law and judiciary. See, we follow Westminstership jurisprudence, criminal jurisprudence. We say the respondent superior, that is the word, respondent superior. That means we may remain silent. The person who files suit or criminal case must prove his case. But in some cases, slowly we are liquidating that concept. So many things Indian Evidence Act has to be revisited. Our High Court also recently has stated that 65 of the Information Technology Act should be revisited with as to how these documents of electronic communication be accepted, appreciated and marked. This way is there. Therefore, these things are there. Then what else the concept you should understand? In first I will go to Constitution of India. For Constitution of India, these topics are most important. Fifth and substances, inconsistency, occupied field. You must understand all these three about passing legislation by union government, state government, and concurrent list, which may be passed both by the union and state, and the procedures are being totally different. That you have to understand. So this topic should be understood for Constitution of India. Then another main aspect was federal constitution, quasi-federal constitution should be understood. Then the another most important is our constitution is sovereign, socialist, secular, democratic Republic of India. So the term what is democratic, what is republic should be high topic. You should understand. Unless and until you understand that these two topics, it is not up to standard that you understood the constitution. So for that you be prepared, then I will take you what all are these topics. And unless and until I get some get back from the students that which topic you want to discuss, till then I will go on giving you the topics. Then criminal procedure code, what topics should be understood. The criminal procedure code, you must particularly your question paper may be on jurisdiction of the courts. Pecuniary jurisdiction is not available except there is absolutely no pecuniary jurisdiction, but territorial jurisdiction are there. And one more thing was that place of occurrence, continuance of offense, and therefore this jurisdiction is most vital to understand what will be the flag territory. What happens if any ambassador of Indian ambassador something had happened, then in which place the trial will be conducted. All these things should be separately understood. Therefore, the topic may be territorial jurisdiction of the criminal courts. That is, you have to go through it, understand. Then civil procedure code, main thing is what kinds of suits being filed. That is most topic. Title suits, money suits, and summary chapter suits. These things should be understood. Then another topic may be most important. Another topic may be what is res judicata and sub judice. What is res judicata and what is sub judice? These things, civil procedure code, you should understand how to get over with this. Then if we come to other acts, what other acts? For other acts, the other day I have told you, the complaint means the magistrate, either written or oral, take cognizance for initiation of proceeding. Therefore, 190 CRPC, there are three categories of complaint being taken on cognizance, on file and cognizance. Number one, by filing private complaint by any individual. Number two, by public servant other than the police officials. So they can file a complaint and that will be taken on file by the magistrate. Third one is a final report filed by the prosecution. So this final report will be the major topic for you to understand. So today I will stop here and request you to look into these topic subjects so that you can understand deeply when we refer, consolidately, picking, going through, understanding the relevant sections so as to answer the questions. Best wishes.